Okay, good morning, everyone. Welcome back to the final day of the inquiry. We have one more witness for the Ministry of Defence, which I think we intend to get through probably this morning. So are there any other matters before we proceed on to the final witness?
And just nothing additional from our side either, ma'am. The next and final witness on behalf of the MOD is Mr. Desmond Egan, who is sitting to my left. Good morning, Mr. Egan. By way of introduction, you should first have before you your supplementary, your inquiry report, your supplementary inquiry report, your initial recognition, and your supplemental recognition. And by way of introduction, if we look to your inquiry report in section 1, you say that that report has been prepared by yourself and that your Assistant Head of Estates Safeguarding at the Ministry of Defence, Defence Infrastructure Organisation, the DIO, based in Whittington, and that you've worked for the MOD for over 24 years and have been in your current role since 2017. And your CV is incorporated to the end of the report, and we'll have a look at that in a moment. And in your role, you have been responsible for ensuring the safeguarding of the Eskdale-Muir seismic array, which includes ensuring that the threshold of 0.336 nanometers is not exceeded by wind turbine development within a 50-kilometre radius of the array. And I don't think I need to take you to section 1.3 and following, but that sets out what the Defence Infrastructure Organisation is. Is that correct?
Yes, that's correct.
And if you can turn to the back of this report, your CV is set out, and there's a little more detail about your employment history. And we can see that you're Assistant Head of Estate Safeguarding since September 2017 at the DIO, and you explain in a number of bullet points what that involves. And we can see that your current position was a progression from other positions with the MOD dating back to 1998. Is that correct?
Yes.
And your academic qualifications are finally listed. You've got a BSc Honours in Math and Science and an HND in Land Administration, Geographical Techniques.
Yes, that's correct.
I don't intend, Mr. Egan, to take you line by line through either your reports or your recognitions, but by way of a general introduction, are you content that those be adopted as your evidence to this inquiry?
Yes, I am.
There is perhaps one matter, however, I'd like a little bit further information from you and a little bit more explanation, and that relates to the wind farm developments at 20 Shilling Hill and Little Hartfell. And in your role as Assistant Head of Safeguarding, are you aware of those developments?
Yes, they are two wind farms that have been received by the MOD for assessment that are within the 50-kilometre consultations on that.
And there's something which they are two developments which came across your desk?
Yes.
Okay. Could you have your supplementary inquiry report before you, please? And you discuss in paragraph 4.19 and following the 20 Shilling wind farm development. That's on page 8. Do you have that?
Yes, I do.
We can read this for ourselves, but I think it's being suggested that what happened at 20 Shilling is similar or analogous to what the current applicant is proposing. Do you see similarities?
I think, Mum, I would consider the 20 Shilling Hill application to be different to the Foreside one that's before the inquiry. The 20 Shilling wind farm originally came to MOD before the Foreside wind farm, and we had sufficient capacity within the noise budget. So we were able to not object to it, and it got consented. The developer then sought to vary the consent, and I think Mr. Thompson said in his evidence correctly, as far as I'm concerned, that they were seeking to increase the turbine heights. And as a consequence of that, it is likely that taller turbines will require more noise budget. That variation came in after the Foreside application. So at that point, we knew that the budget had been reached by Foreside. So therefore, we lodged, within MOD, we lodged an objection to the variation. The planning authority decided to consent the 20 Shilling Hill variation with a planning condition. And Ma'am, I think one thing I'd like you to note, if possible. I think Mr. Thompson possibly mentioned in his evidence, his oral evidence, that MOD agreed to the condition and to the mitigation. That's not quite true, in so much as MOD didn't agree to the planning condition. Unbeknownst to me at the time, there were multiple engagements going on between myself and the developer, and between the developer and the planning authority, and I wasn't party to the latter one. And it seems that the engagement between the developer and planning authority was sufficient to persuade the planning authority to grant the consent with a condition. I did happen to speak to the planning officer to see, well, why did you do that? And they said to me that they've known that MOD has previously participated in many air traffic control radar related mitigations, which was true. We have been doing that for a number of years, since about 2007. There's a well established process for that. And the planning officer just assumed that the SWR array was somehow comparable to air traffic control radar, and as such, a radar type condition was applicable in this instance. So, with my engagement with the developer, they offered to demonstrate to the MOD that their variation wouldn't need the additional budget due to their taller turbines. So they went away with the commission design engineering to do some work, which then led to MOD and the developer entering into the legal agreements, which I think is detailed in, well, say detailed, it's referenced in paragraph 4.23 of my supplementary inquiry report. I can't really speak about the legal agreement in more detail because it's confidential between ourselves and the developer. But the thing for me, and why it makes it, I think, different, is because in that instance with 20 Shilling Hill, the developer wasn't challenging the science, the algorithm, and they accepted that, and their mitigation was within the bounds of the existing established algorithm and tool that we use.
Thank you for that explanation. And if we could perhaps just look at some of the correspondence, albeit briefly, first by reference to the fact that it's not quite correct that you agreed to the condition, as I understood you. Could you have before you an applicant's document 01.077? Which hopefully is an email from yourself, I think, dated 2nd September 2019. You have that. We can all read this for ourselves, but in due course. But does this reflect the explanation which you've just provided to the reporter regarding how your understanding of how the condition came about, and that you'd had discussions, but we can see this further on into the document. The purpose of the fourth paragraph. The purpose of the discussion is to provide the applicant with an opportunity to provide evidence regarding the recalculation of the budget. Whilst I hope the applicant can provide the evidence, there's a risk there is no solution. And then the discussions have also broached planning conditions and the route to potential discharge. And then make a suggestion, and you say you'd have liked to be able to submit the agreed conditions, and it's disappointing, reading short, that you didn't consult us regarding the wording.
Yes, that's correct. I think when we were consulted about the mitigation for 20 Shilling Hill, it was a case that there had never been a mitigation proposed before. So it's a brand new, sort of pioneering area for us. So in the position that MOD was in, whereby we've got a condition, we were trying to find how we could proceed with it and make it work. We are, believe it or not, I know the applicant may not agree. We are an open and approachable and reasonable government department. So we had this condition, and rather than pull down the shutters, we were trying to think, right, well, how are we going to make this work? And at that time, to be perfectly honest with you, I had no idea, because we had never come across this before.
And staying in this penultimate paragraph, about halfway down, you write, the mitigation scheme will need to be comprehensive if it is to provide MOD with required evidence to recommend discharge. It will not just be a paper exercise. In fact, it will need to allow for testing and evaluation of the turbines. Now, you've told us about the legal agreement, albeit you can't tell us much about the legal agreement due to confidentiality. But does it contain provisions relative to testing and evaluation of the turbines?
Yes, ma'am, it does. I'll just refer you back to paragraph 4.2.3.
And if I understand your evidence correctly, you're explaining to the reporter that the mitigation which is to be implemented is within the framework of your existing algorithm and predictive tool.
Yes, that'd be correct. Sorry, I used the terminology boundary.
Boundary, okay.
Yeah, that's what I meant. Framework boundary, yes.
Thank you. And you also tell us a little bit about Little Hartfell at paragraphs 4.26 and following of your supplemental report. Again, if you could explain to the reporter if you see any difference between what happened in Little Hartfell and what the applicant is proposing in this inquiry.
So Little Hartfell was a wind farm application that came into us after Foresight. So obviously at that time there was no budget, so we objected to it. We've actually been consulted, I think, on 5 applications for this wind farm. and we've objected throughout, apart from the fifth iteration, which is currently with MOD, and that's to extend the life of the wind farm from, I think, 25 years to 30 years, and we've yet to respond to that. For Little Hartfell, that again was consented. I think it was possibly the second application that got consented, and it was consented with a planning condition again by the planning authority. In that instance, there was no agreement about the condition from MOD. In fact, there was no dialogue whatsoever involving MOD and the planning authority and or the developer regarding the planning condition. I think the wind farm was consented, I think, 2 or 3 years ago. Yes, yes, the 9th of June 2020, and the developer has not approached MOD regarding mitigation or discharge of that condition. So I do not know what their intentions are.
Thank you, Mr. Egan, for that explanation. Having listened to the evidence over the course of the past 3 days, and having adopted your reports and recognitions as your evidence to this inquiry, is there anything further you would wish to add, or anything which requires to be revised or amended in your reports or recognitions?
No, thank you.
Thank you. I have no further questions, Mr. Egan.
Mr. Hardy, you have questions for Mr. Egan?
I do. So in terms of documents, Mr. Egan, I can suggest we'll need the onshore wind policy statement, which you probably have, then CDs 14078, 079, 087, and then APP 077 that we just looked at. We might need to look at the scope of works 089, but I suspect not. So if we could have those, I'd be very grateful. It's also going to be a general question about documents produced on behalf of the MOD, and it maybe you can answer without any particular documents, but if you do, then it would be helpful to have the inquiry statement, the supplementary inquiry statement as well. Do you have all those? Good. And if you need any time to find a document, just say, and of course we'll stop.
No, thank you. I've got them, some on hard copy and some.
Excellent. If you need time, just say so.
Thank you.
So some general points to start with. This is a planning process, of course. It's driven by statute. And within that process, important though any statutory consultee is, the MOD doesn't have any super status, does it? It's not a super consultee, if I can put it like that.
No, that's correct. I would agree with that.
So a little bit like SEPA or Historic Environment Scotland or other people. They are all parts of the process, but it's not that you've got a sort of gold star against the MOD that what you say automatically goes.
No, when we haven't got a veto in this sort of thing. You'll be aware, I think, one of the documents lodged is the actual the map, the technical direction map, which depicts the consultation zone. It's a 50 kilometre
Of course.
zone around the array, and I would refer to that as a consultation zone. It's not an exclusion zone in terms of the 10 to 50.
Well, it's a rather different point, isn't it? Of course, there are obligations, there's the treaty and so on, and there's a responsibility that the MOD has for a number of things, including looking after the array. That's its responsibilities on that side, if you like, the technical side. But in the planning process, it is there as a consultee, will have its say, but there's no magic to what the MOD has to say in any consenting exercise.
No, there's no magic.
Thank you. And you said you used the word no veto. No, so there's no veto as a matter of law, but nor is it right that there should be a de facto veto. So in other words, there shouldn't be an unwritten rule that, well, that's what the law says, but actually the MOD should have a veto. So that's not right either, is it?
I wouldn't consider that to be the case. We being MOD have our consultations on. We are a consultee. We do our assessments. We make our representations to, in this instance, to safeguard the array.
Yes, but in the process, I mean, actually, you looked at the 20 shilling little heartfelt examples there, where, I mean, you indicated the local planning authority exercised its statutory functions under the Planning Act. You said in a couple of cases it didn't listen to you. That's the process, isn't it? Either the local planning authorities, or in Section 36 cases, the ministers will make a planning decision having listened and acted according to planning principles.
Yes.
There's no disrespect, you're not a lawyer.
That's correct.
So you do discuss suspensive conditions in your documents, but that's not on the legal principles. That's a matter of legal submissions. Is that right?
Yes.
Familiarity that you have, so not as a lawyer, but familiarity that you have with the law relating to suspensive conditions is what?
So it'd be limited, personally, for myself. The role that myself and my team has in terms of safeguarding any asset that we look after, whatever it may be, we are supported by relevant experts.
Yeah.
No matter what the asset is, we have experts for it, so we rely upon the input of those as and when.
Let me ask a more precise question. In your documents, you do deal quite a lot with whether it's right to attach a suspensive condition and competence and so on. I just want to know whether it's right to be able to ask you any questions about that, or whether truly that is a matter of legal submissions through your counsel.
I think that would be a case for legal submissions.
All right. Then I shall do that in writing. There is a document which is in the core documents. That's CD 14087. Let's just test that slightly. So this is wind turbine consents, aviation objections, and associated negative conditions. You got that?
Yes.
Is that a document with which you're familiar? If not, that's fine, and I will genuinely leave it to legal submission. But if you are, then I want to just ask you something.
So it's a document that I have read. So I guess I have an awareness of it. Well, to what extent I say I'm familiar.
Well, shall I put the question? If you think it's unfair, then it absolutely can be left to legal submissions. And the test is this. There's no requirement, is there, for an applicant to show reasonable prospects. As long as it's greater than a nil prospect of being discharged, it's appropriate or can be appropriate, subject to usual planning discretion, to impose a condition. Is that a question you feel you can answer? If you can't, it can be a matter.
I think I would leave that for legal submission.
Very good. Let's deal with that through legal submission. In terms of competence, then, of the condition, because you do deal with that in your documents, and I'd hope you would be able to at least respond on those points. So it's page 5, section 4.2.
Which documents are we looking at?
This is your supplementary inquiry report.
And the paragraph number, please.
4.2. You have that?
Yes.
I'm having to pick through this quite carefully because competence could be a legal concept as well, and it's difficult for me to know what you are saying you can answer and what you can't. Yet this is in your material. So, did you write your paragraph 4.2?
Yes, I've been involved heavily in the drafting of this document.
Well, slightly different point. Did you write paragraph 4.2, which deals with competence of a suspensive condition, or was that written for you?
No. So I've drafted this, but it has been obviously reviewed by my legal representatives.
All right. So what you're saying is you can't give evidence in relation to the legal test for imposition of a suspensive condition, but you did write this section on competence so far as that's a legal concept. That's your evidence.
I can't really comment upon the legal element, like legal concept.
All right. Well, let's try this. In paragraph 4.2, you say it's incompetent because, let's just leave aside any legalities, it's just common sense. You say it doesn't work, let's use that language, because it relies on a range of poorly defined research projects, themselves subject to amendment on a specified basis without defined deliverables, no way, we've read this wording before, no way of knowing how the effects on the detection capabilities of the array to be assessed, encapsulates principal difficulty, relying on further investigation of effects and so on. That language comes from the statement of case, or very similar language in the statement of case, which we put to Dr. Bowers yesterday. So, general question I've got about the case. Did you have any part to play in preparation of the inquiry statement?
Yes, the original statement of case and the updated statement of case, I've been involved as part of the wider team who have been drafting these documents.
So the question I'm really asking is the origination of this idea about incompetence. So the fact that there aren't well-defined deliverables, poorly defined research project, the no way of knowing how the effects on the detection capabilities is to be assessed. That's in your paragraph 4.2 itself. Where did that wording come from? Is that your wording? Or did that come from, say, Dr. Bowers or someone else?
It's a reflection of the MOD position.
Mm-hmm. It's not quite an answer to my question. It's specific wording, paragraph 4.2, but is that your wording? Is that your concern? Was your wording the origination of the MOD's position? in relation to competence?
So the wording is it's influenced by the MOD statements of case.
Yeah.
It's consistent with that.
I know. That's what I'm asking. I want to know where that wording came from. Is that your wording? Is that Dr. Bauer's wording? Where did it come from? Who wrote it?
And so I'm talking about the MOD statement of case first, or do you want me to comment on
the language? Is very similar in the statement of case to what you say in paragraph 4.2 of your supplementary report, and it says things like poorly defined research projects without defined deliverables, etc., etc. Where did that wording come from? Is that your wording? Was that Dr. Bauer's wording? Was that who wrote it?
The specific wording, I can't recall exactly, Mum. It's been, as I say, there's multiple parties involved in the drafting, and we've had multiple, obviously, as the drafting of the document matures. There's been multiple versions of it, so I can't recall.
You heard the cross questioning yesterday of Dr. Bowers, didn't you?
Yes.
And what will have become apparent, I suspect, is that Dr. Bowers, or certainly the submission that would be made, is that Dr. Bowers was acting under a misapprehension about what needed to be in the scope of work. So he was looking for something at a higher level of detail, if you like, in the scope of works than was ever intended. So,
pausing there, I'm not sure we accept that hypothesis.
No, that's what I said. That's going to be the applicant's submission.
I misunderstood the way that you framed the question.
So the applicant's submission will be Dr. Bowers misunderstood that. So in terms of definition of deliverables and those other things, you've now heard the evidence and you've heard what the applicant is saying the scope of works is intended to do. Do you now accept that actually what you put in paragraph 4.2 of those points have actually been met?
So from my perspective, as a layperson, Ma'am, I am not a scientist and I can't pretend to understand the science that's being discussed in great detail at this inquiry. From what I have heard in the last few days, I am still of the opinion that the MD position remains. We don't accept the science at the moment.
You're missing the point, with respect. Not about the science. This is about whether or not the suspensive condition is competent. What you say in your paragraph 4.2, poorly defined research projects without defined deliverables and criteria to measure success and failure, no way of knowing how the effects are to be assessed, and so on. Now, the scope of works, which is at CD 089, presumably you've read it.
Yes, I've seen it. I've been through it. Again, I'm not an expert on that sort of thing.
But you don't need to be an expert with respect. The reporter, local planning authorities, ministers aren't going to be experts either. That scope of works has been set out by and explained by the witnesses here. It's absolutely clear, isn't it, about the scope of it. You might disagree whether it's going to make any difference, but that's not the question. It's clear, isn't it, what it's trying to do? Data collection, the scale of the ambition, how the data is going to be processed, matters are going to be taken into account. So it's not right to say it's not clear, is it?
Ma'am, I can't really comment upon the detail of the scope of works. It's a very technical document, and Dr. Bowers has given his evidence, the written evidence and the oral evidence, and Dr. Bowers is acting as the MOD's technical expert.
Well, I'm very troubled by that answer, because in paragraph 4.2 you criticise and say that consent should be refused on the basis that what's proposed is poorly defined, lacking clarity, no deliverables, etc., etc. So you feel able to criticise to a point of saying consent should be refused, and yet you refuse to all say you can't answer questions on the document on which those comments are based. How is that right?
I think, it's important to remember what my role is within the MOD and the SDAR array. So I'm charged with safeguarding the array to ensure that the detection capabilities of the array are not compromised. So based on what's being put to MOD throughout this process, which MOD is fully engaged with, we've reviewed everything that's come into us. We've tried our best to understand and provide information back to the applicant. I think it's fair, again, from my perspective as a layperson, it seems to me that throughout the process, the applicant's case has evolved, which you may expect, maybe expand. So we've been trying to keep up with that and understand it. We haven't found it easy to do that, but we've tried to be as reasonable as we can to do that and to react to what's been put before us.
Again, I'm troubled by that answer. Mr. Egan, did you, in writing paragraph 4.2 of your supplementary inquiry report, actually look at what was being proposed by the applicant?
So, yes, is the answer.
Including the scope of work?
Yes, but I'm not a technical person, so I wouldn't consider myself to be suitably qualified or experienced to provide a comment on the scope of work.
Right. So Dr. Bowers, you recall, and I've got a clear note, and no doubt somebody could watch it back on the video link, said that he had had, quote, a quick look, application being in his spare time because he hadn't been allocated any time by the MOD at the scope of work. So that's the full extent, is it? You're deferring to Dr. Bowers. Dr. Bowers had a quick look. That's it, isn't it?
So I can't comment upon the priorities of Dr. Bowers.
I'm asking you to. Is that your evidence? Are you deferring? Because this obviously will come back and close it. You're telling me it's not for you, it's for Dr. Bowers. The evidence from Dr. Bowers yesterday was that all he had done was give the scope of works a quick look with a clear implication that was in his spare time because he hadn't been allocated time. Is that the evidence?
Ma'am, it's not really for me to try and qualify what Dr. Bowers said. Dr. Bowers is, he provides technical input, opinion, support to MOD regarding the SDAR related matters.
So the quick look, that's the evidence. The quick look from Dr. Bowers, that's the only evidence that the MOD has to propose what is in paragraph 5.1 of the supplementary, if you want to turn to that, to the supplementary inquiry statement, which is in the same words as your paragraph 4.2. So it's on page 10 of the updated statement, where the applicant's proposed condition is incompetence the same way, because it relies on a range of poorly defined research projects and so it's the same wording as paragraph 4.2 of your updated report. You can see that?
So the content is consistent?
Yes. So the only basis, so the MOD has come to this inquiry, the only basis for that objection, as articulated in section 5.1 of the updated statement and underlying paragraph 4.2 of your updated inquiry report, is a quick look by Dr. Bowers. That's it, isn't it? You can't comment on it. You still told us that. It's Dr. Bowers. Can't modify what Dr. Bowers has to say. It's a quick look. That's all it is, isn't it?
Ma'am, I'd only be repeating what I previously said. Dr. Bowers is the technical expert, and he's provided his written and oral evidence.
So, if that's right, a quick look from Dr. Bowers, we've certainly heard nothing else. You described the MOD as being open and approachable government department. If the applicant would disagree, but try to be constructive and helpful, right? I mean, that's you know what's coming back from the applicant, that the MOD has done nothing in this case to assist. And if the evidence is quick look, then we're here on the back of a cursory examination of the applicant's proposal for this nationally significant project, aren't we? That's where it gets to.
I think it's important to remember that at every stage, as the applicant's case has expanded, we have taken in what's been submitted. We've looked at it. There's been meetings between the experts to the scientific experts, to try and narrow the gaps. So we have engaged as best we can, and we've had to react as the applicant has provided their information.
It simply isn't a credible answer, Stephen, if you don't mind me saying. The case for the applicant
With
has...
respect, that's probably a matter for the reporter.
Well, credibility, I'll go to why I say that. Because the case, the suggestion has been put that the case is modifying, the MOD doesn't really know where we are and so on. The case has been set out for months, hasn't it, in relation to the updated position. The condition has been set, and actually the engagement that you're now suggesting may have been worthless if in fact it was based on a quick look from Dr. Bowers. He can turn up at meetings, but if he's got no instructions and hasn't actually looked at the information, we're not going to get anywhere, will we?
A little bit to unpick there, Mum. I think, as I say, MOD has engaged throughout all of this. I'm not really sure I can say much more than that. The papers and submissions have been made, and you can see what's been done and when it's come in, and what we've done.
Let's move on. Then let's move to the future, because hopefully new dawn, and the MOD presumably will go forward in the spirit of collaboration and openness that you've indicated. That's the intention, is it?
So, Mum, if I could give you an example, there's many references to the Estonol Working Group, which is a forum chaired by the Scottish Government. It's been sitting for a number of years, well established, seeking to deal with the matters relating to the array, the tension between the array, the constraint, I should say, between the array and renewable energy. And MOD has been involved in that since the beginning. It's been involved in the research. So that's an example of what we do, and we're committed still to working with that. But in addition, we also will look at anything else that comes in and could take things forward. As I say, I'm a lay person, Mr. Harvey. I don't understand the science. I started my role in 2017. In 2018, obviously the application came up before side. We had the working group was reconvened because obviously the budget had been reached. The applicant, Mr. Thompson, attends the working group, and I was very happy when at the working group several years ago he did say that he had the science and would share the science with the group. For me, from my perspective, dealing with the safeguarding of the array, where I knew there was no budget left, that is very could be very good news, because potentially that could help unlock the situation that we're in with no budget, and then the science, for whatever reason, and I can't comment on why, Mum, it wasn't put before the working group for consideration. I do believe Mr. Thompson mentioned that I think toward maybe the latter stages of things, that for, I think he mentioned statutory reasons he couldn't do that. So again, I don't wish to speak on behalf of the applicant. Perhaps it's because of the this inquiry process prevents him sharing that information in the latter stages.
I'll let you go on. It wasn't an answer to my question, Mr. Egan. I'm talking about this application, this applicant, to do the EWG. You, given your transparency and openness, there's a commitment, is there, from the MOD to engage collaboratively with my client going forward?
So, Ma'am, if I can just zoom out a little bit, MOD, from a safeguarding perspective, so I was a bit conscious of yesterday's situation. Okay, thank you. So we're zooming out. MOD does work with all sorts of developers to try and find solutions. So, for instance, I've mentioned radar previously, because that's one that people are maybe most familiar with, and we'll work with them to try and find appropriate mitigation. And we've done that numerous times. In terms of the array, and based on your array, some mitigation is not something that's easy, and it's not something that has been established. So it's something that hopefully will occur in the future.
It's a very long answer, Steve. It's not what I was asking. So this application, and this applicant's got every right to pursue a planning application, consenting application. What we have is a scope of works, and you know that the draft condition then requires a scheme, a detailed scheme to be submitted. Is the MOD going to work collaboratively with my client if it has any concerns about the scope of works, so that that can inform the schedule of the scheme? We're going to do that.
So, I'm doing it again. MOD will respond to what is put before it. I would caveat, if I may, that there is a balance to be had between which party is ultimately responsible for delivering the solution. So I wouldn't want to suggest that MOD is going to be able to solve this situation.
Yes, I just don't understand, because the applicant has an application which goes through the consenting system, and it is proposing a scope of works which it's entitled to do. It is inviting the MOD to work with it, help improve it, look at it if it wants to. If it doesn't want to do that, then the MOD, of course, will be consulted by the LPA in due course. So all I am trying to understand is whether there is, given your transparency and so on, a commitment that you feel able to give about working with my client, yes or no?
Ma'am, I would expect the MOD to continue to engage and involve and get involved with hopefully the resolution of or the improvement of the current situation where we've got no budget available. And if that's with the applicant, that's absolutely fine. It could be with other applicants. It could be with the working group.
Yeah.
We're open to engagement, meaningful engagement to take matters forward.
So the way it works, or would work, is this. I mean, leaving aside, it took 2 years in relation to Harriet 1, delays and all that, but just leave aside, just look forward. Let's just say new door, right? The MOD can engage on the scope of works to do that. If it doesn't, the applicant will then submit a scheme. At that stage, the MOD could be consulted by the LPA, could engage or not. If it doesn't, then resolution, the MOD's had its chance, or would have had its chances, it would be determined by the planning system, wouldn't it?
Yes, I'd agree with that.
Yeah, there's nothing wrong with that. That's a planning application in the planning system. You're not a super consultee. That's the way it works, isn't it?
The system, I would agree with that.
Uh-huh.
I think one of the things I will take away from this inquiry is just how complex the science is to the layperson, and there's been a good level of scrutiny of that science at this inquiry. I am not sure whether that level of scrutiny of the science would occur, for instance, at a planning authority, should they have to consider a suspensive condition.
It's no different, Mr. Egan. I just don't understand, because the local planning authority is the statutory authority, or administered in section 36. It seeks consultation responses from a number of consultees. It seeks a consultation response from the MOD at the moment. Might be on aviation, radar, whatever it is. It has to decide, doesn't it? It has to see what the science is. It will listen to certain people. It may override certain people. That's all that's happening here. You've got your opportunity. We're actually begging you to get involved, do the scope of works. That's great. Get the best scheme. If you don't want to do that, that's fine. We'll go to the LPA. You get your chance to have your consultation, Dr. Bowles, whatever you want to do, and the LPA will weigh that up in the normal way. There's no difference, is there?
Ma'am, so being charged with having to safeguard the radar, the array, I've mentioned already about the council, the planning officer, considering the array to be a radar, an air traffic control radar, which is concerning, given they're two very different assets. We've got, and I don't think it's in dispute, the array, the significance of the array, the importance of it. We've got national and international obligations to fulfil. So it's a very important asset. And you can see how easy it is for errors of judgment to potentially occur, which could then lead to the detection capabilities of the array being compromised. And that's an unsatisfactory position for myself.
So you are seeking a veto because there's no different with respect, Mr. Egan, to aviation, radar. You could use another example. SEPA, the Environment Agency, Coastal Flood Defence. That's what they're concerned about. And what they have to do, the LPA will consult them, say, on a flood risk scheme, and they're very important things, but the LPA and the planning system has to decide. This is no different, is it?
Well, I think there are differences of opinion regarding the science. So we are not bridging the gap in this inquiry, in so much as there has been engagement between the technical experts on both sides. It hasn't found, I think, enough common ground. So the MOD position really remains that we just cannot really put the array at risk.
Yes, I get that. I think you misunderstand. Let me try one more time. Let's read it. The applicant is seeking a suspensive condition. If that suspensive condition is not discharged, ain't no turbines, ain't no risk to the array, right? So, the scope of works which the MOD can get involved in, can choose to or not, goes to the LPA. The LPA will consult the MOD. The MOD can say absolutely no way, don't agree with the science and so on. Only if that gets discharged, based on all that evidence, would consent be granted. That's the process, isn't it? No different to anything else.
Yes, and it's the fact that the condition could be discharged that is the concern.
What do you mean that the science may actually be different to what the MOD thinks the position is? After due discussion, there'd be determination made. Dr. Bowers, you, anybody else in the world on behalf of the MOD can make its representations as part of the process. That's how the planning system works, isn't it?
It's how it works, but I think again, I think I might be repeating myself here, but it's the level of scrutiny of the science. I do not understand how we'd get that level of scrutiny by a planning authority seeking to discharge a condition.
Yeah.
They're going to be, in theory, they could have two pieces of paper, one from the applicant saying discharge condition because here's our science, and then another piece of paper from MLD saying we don't agree with that science, please don't discharge the condition.
Yeah, that's the process. Stephen, it's exactly the same as say if lives are at risk behind a coastal flood risk defence or anything else, just exactly the same. That is the planning process, decisions have to be made. Let's just try and move it on a little bit. Of course, be open to the MOD to judicially review any decision that it thought was irrational. Could do that, couldn't it? It could take its issues to the court.
So I'm not a legal expert here, but I understand, yes, if a condition was discharged, MOD would have to consider that very carefully. Yeah. And it is likely, whilst it's likely, shouldn't preempt, we would have to consider challenging that decision.
Yeah.
And it could be judicial review. And my understanding is that at that forum, there still wouldn't be the level of scrutiny on the science which has occurred at this inquiry.
Yeah. So put all those things together. Just listen a little bit to yourself. What you're actually saying is the MOD wants a veto on the science because it doesn't trust the system. And actually, you want to be in control of the process. You want to be in control of the science, and only you will do. That's it.
No. So in terms of being in control, MOD needs to be able to fulfil its obligations. To do that, the array needs to be safeguarded. To safeguard the array, there's an established tool that I used, me and my team use to work out the noise budget. That tool uses established algorithm, and that algorithm is based on established science. So that's been in use for a number of years. So that gives us the ability to safeguard the array and fulfill our obligations.
I mean, what you're saying, in effect, Stephen, is you don't trust the planning system or indeed the courts as the backstop to do their work. Because the MOD, the way you portray it is the MOD just wants a veto. That's how it is.
No, I've said, Mr. Harvey, that we haven't got a veto. I'm not suggesting we have. I haven't done that in any of my evidence.
But we're trying to unpick it because you say that, but what the evidence you then gives or you've given leads to exactly that result, because the planning system is the way that the applicant has its statutory right to take things forward. You absolutely have the right to object. You can make your points, but that's done within the system. What you're seeking to do is to say, no, this applicant cannot bring this scheme forward. That's what you're saying, isn't it?
No, I think MOD has its right as a consultee to make its representations, and in this instance, we do not agree with the applicant's case. And we've made our representations.
So if the planning system agrees with you, turbines don't get built. It's fine, there's no risk to the array. All the applicant is saying is, well, we disagree, we've got science, there's a good chance that the parameters Q and V can be changed if that's right and to the satisfaction of those that make the decisions, having listened to the MOD. Away we go. That's where we are. That's the system, isn't it? That's trusting the planning system, not saying MOD only.
I don't think we have said MOD only.
I've got very clear evidence from you, Mr. Egan. I'll make my submissions. The report has got the point. OWPS, if we could turn to that. So CD 812. You got that?
Just 1 second, please. Yes, I've got that, thank you.
Okay, just some points. So we're in section 7.2, in terms of page 42 onwards. I'm sure you're familiar with this. So what the government's done is reaffirmed the 50-kilometre consultation zone and the 10k exclusion zone without change.
Sorry, I'm just catching up with you. Could you repeat that?
Yes. So in this document, you can see this from 7.2.3, 7.2.4. The Scottish Government has reaffirmed the 50-kilometre consultation zone and 10-kilometre exclusion zone without change, hasn't it? It's not altered them.
Yes, that's correct in this document, yes.
Well, yeah, this is the document, isn't it? There's some sort of hesitation there. This is the brand new policy statement that was adopted last month.
Yes, no, I'm not disputing that.
Right, good, thank you. There were some options, I think, contemplated in the policy consultation, and they haven't been taken up, have they? What we've got here isn't what was seen in the consultation document.
Yes.
The algorithm we know or the government has identified that the algorithm used by the MOD to calculate the budget takes a conservative approach and by design overestimates the seismic contribution of each wind turbine.
Yes, Mum, I think the MOD's evidence does state that we take a precautionary approach to safeguarding UA.
Well, it's a different point, really. That you say precautionary approach, but the acknowledgement or the policy position is that there is an overestimation of seismic contributions to turbines, isn't it?
Mr. Harvey, could I just ask you to tell me which paragraph we're looking at, please?
Yeah. Let's find that. Nine. Yeah, 7.2.9, not 7.2. 7.2.9. So looking at Scottish Government policy through a series of technical evaluation studies, we identify that the algorithm used by the MOD to calculate the budget takes a conservative approach and by design overestimates the seismic contribution of each wind turbine. That's position, isn't it? You just wanted me to take you to the reference. That's what. So that's not just that's not a precautionary approach. That is the policy position of the government that the algorithm is conservative and by design overestimates the seismic contribution. That's what the government has said. You wanted me to take you to that point. It's not. Yes, I am. You said a precautionary position. That's different, isn't it? You might want to take a precautionary position, but the policy position of the government is that the algorithm overestimates the seismic contribution of each wind turbine.
And I don't think I can comment on what Mr. Harvey's saying. It's a Scottish Government document, so it's their document. They're the authors.
Yes, the question is just this: that is the government's stated position last month. It's not one just about a need for precaution. The government's policy position is that the algorithm overstates the seismic contribution of turbines, doesn't it?
And yes, that's what it says in 7.2.9. I'd agree with that.
And it would be bad, wouldn't it, to operate an algorithm utilising scientific values once you knew why and to what extent that overestimation was taking place.
So the algorithm that's currently used within the toolmark, that's based on the established science.
So the point is, and the government is saying that algorithm, based on the established science, is overestimating the seismic contribution from each wind turbine. So in other words, it's finding more seismic vibrations than is in reality. That's not a sensible position to persevere with, is it?
Sorry, Ma'am, I'm slightly concerned about the aridity of this discussion. The MOD self-evidently is not responsible for the Scottish Government policy. and vice versa. The Scottish Government is not responsible for the manner in which the MOD safeguards the array. Clearly there is maybe a mismatch between the two perfectly understandable policy aspirations, but I'm not really sure it's appropriate for Mr. Egan to comment on what the Scottish Government may consider. Equally, I'm not sure it would be appropriate for a representative from the Scottish Government to comment upon what the MOD consider is appropriate. So I do wonder where this line is going.
Mr. Hardy, can you clarify?
Yeah, it's not appropriateness. It's the difference because or the difference between a precautionary approach, which is what Mr. Egan was suggesting, and the policy position of the government, presumably having listened to the MOD, that actually the algorithm is overestimating seismic contribution. So it's not just that we need to be careful about the array. The government's position, recently stated, is that the algorithm is overestimating, isn't it?
So I can agree with what Mr. Harvey is saying, as much as he's reading out and referencing 7.2.9. I can't comment upon documents because it's the Scottish Government policy. But I think it leads on to the series of technical evaluations and studies, which is the work being done by Xi Engineering under the auspices of the working group, the Samuel Working Group, which MOD is involved in.
It does not need to be done through Xi Engineering, though, does it, Mr. Egan? That might be your preferred choice, but what the applicant is saying in this case is actually you can keep the algorithm as it is, but you can change the parameters Q and V, you can maintain the safe protection of the array, but you can facilitate renewable energy generation. It's perfectly possible, perfectly valid, isn't it, as an approach?
Ma'am, firstly, I'd just like to clarify that MOD hasn't got a preference as to who conducts the work or who comes forward with science. The series of technical evaluations and studies referred to in 7.2.9 is being taken forward by the Scottish Government. So MOD, obviously, as I've mentioned, we discuss matters through the working group, which is where this topic is normally discussed. However, again, I can only repeat that MOD will consider any new information, data, science from wherever it comes.
Yeah, so that no preference will include the ability to engage with work that comes forward through the scope of works in the scheme in this case. You've got no preference, you can work with people like Professor Macbeth and Professor Stars, can't you?
Ma'am, it's slightly difficult to answer that because I can't predict or preempt what may come out of any further work. I'm not a technical expert, and I don't know if there is more positive, constructive science to come in the future.
All right, well, I've got no preference, so I'll make my submissions on that. Mr. Egan. Let's just, we're almost there. In terms of risk, so allocation of risk, you heard what Mr. Thompson had to say. Look, a lot of money's being put into this project, not that's nothing for the client, knows all the risks. But do you accept that in potentially sinking another seven-figure sum into this, that a suspensive condition would be a useful staging post? So in other words, MOD is going to get a free data set, isn't it, where the applicant is paying for this. But in order to put that money in, it would be useful to have the security of a consent subject to a suspensive condition.
Ma'am, I can't make any comment on the commercial or financial matters, models that the applicant may use. I would like to highlight that there is risk to MOD here.
What is it?
Because in the event that a planning condition is to be discharged, at that point in time, we have an ill-equipped planning authority dealing with very complex science, and there could be two opposing views, and MOD will have little influence at that time. Our role will be diminished, which could lead to a discharge of the condition and ultimately affect protection capabilities of the array.
Yeah, that's the veto point, the control point. We've been around that loop lots of times. Not going there again, Mr. Egan. In terms of use of the suspensive conditions, or use of suspensive conditions elsewhere, so we've looked at the 20 shilling wind farm and Little Heart. I mean, you can make submissions on it, but the point is this: the MOD is not implacably opposed to suspensive conditions, is it? The law is for others, but if subject to normal administrative law principles, decision maker poses a suspensive condition, the MOD would be all right, okay with that.
That would be very specific to the circumstances.
Yeah,
I think, Ma'am, we being the MOD, as I've mentioned previously, I think we have used conditions for radars for a number of years, which is an example that's come out in the last hour or two. But for Estalmure, a very different type of asset. We're talking here about, moving, and forgive my my lack of technical vocabulary here, but it's almost like moving the science on, or improving science. So we've got to be confident in whatever science is to be used, and to ensure that the array can be appropriately safeguarded.
Sounds like the same answer again, Mr. Egan. I'm not going to go there. In terms of time scale, another criticism that's made is in relation to that. You've heard the evidence that data collection, being cut in field trials, a matter of weeks, 4 weeks or whatever, and then the suggestion from the condition is that within, at the moment it's square bracketed, but within 12 months from the date of the permission, maybe shorter, don't know, but just work with 12 months, the scheme would be submitted. That's very different to the generalised fear that you set out in your report about years and years and years passing by, isn't it? So if the period is fixed at 12 months, we know exactly how long this would take.
Ma'am, I can't really comment upon sort of scientific research and how long things can take. I can only, I guess, reflect upon my perspective as a safeguarder, as a lay person. As I say, we objected to Foreside Wind Farm back in 2018. We're here, 2023, discussing complex science.
Again, it's not the question I asked, Mr. Egan.
No, but I guess, it's there's a number of years there, and to me it highlights that it's not simple and quick. I can't preempt or predict what might happen going forward.
That wasn't the question asked, of course, because the condition, with which the applicant would be required to comply, at the moment it's got a period of 12 months. It's subject, obviously, to someone else putting a different time period. But within 12 months, the scheme would have to have been developed and submitted. And if it isn't within that 12 months of a breach condition, it wouldn't happen. So there's a time limit there, isn't there? Which gives you, or gives everybody, confidence about the time scale for things happening. Do you see that?
Yes, I see it,
Yeah. So do you agree that is, I mean, quite agree, obviously it's taken too long, but that provides a continuous way of moving things forward within 12 months. It could be less than that. Scheme will go to the local planning authority for the works.
I cannot comment on that. I don't know how long all that could take.
All right. Thank you very much, Mr. Egan. That's all I have got. I'll make my submissions.
Mr. Egan, I have just have a few questions, some of which you responded to there, so I don't need to go into any further. But I suppose leading on from what you were talking about there, could you explain to me what it is about Eskdale Muir, the array, that means that, and I use these words carefully, the remedy seems to be resistant to going down a suspensive condition route, as opposed to their approach with regard to radar? What is it about the array, in your view, that is different?
It's a very good question, man. It's also a very technical question from looking at it from my perspective, and so I'm probably not going to be able to give you a very good answer, I'm afraid. With the radar situation, all of MOD's relevant experts, so we'll start off with, for instance, the radar engineers, and then it would include the air traffic controllers, and then DRS sort of policy people who look after the air traffic control. They were able to look at their requirements and work out what's unacceptable in terms of the impact. So it's not as if you have a radar screen, it's not free of what we call clutter. So there's targets, there's legitimate targets like the aircraft, which wants to take. And wind farms will ping on the radar. But that in itself isn't going to make MOD object just because the wind farm happens to ping. They can, the RF, they can accept some interference, and they're able to work out what they can and cannot accept. That led to the development of a mitigation process, which involves a host of different MOD areas of business to deliver a technical solution, which may be, for instance, a simple one would be the provision of a radar. So all of that is enshrined in a process and captured, and it's been established for a number of years. So it's very well understood how to get potentially from an objection to a mitigation. For Eskdale Muir, we have the established science and tool which me and my team use. tool, it might be worth just mentioning that when we use the tool, essentially as end users, we input the wind farm information, turbine information, locations, heights, rotor diameters, and then it's a clever tool. We simply click a button, the tool will do its calculations, and that tool, we are not able to overwrite anything in that tool as end users. So if the tool had calculated that a noise budget of 10, I think was used by Thompson, was required for wind farm, that's what was calculated. If we were then told actually it's 8, we couldn't go in and override that. Our tool is locked down. So that's what we use to manage the budget, and I don't know how I could safeguard the array if I've got one tool based on one science and then other science, other potentially new algorithms which MOD have no control of.
Perhaps I have a follow-up question to that then. If the working group didn't exist in its current form, and I know it's been reconvened of late to be looking at the stigmata again in this couple of years, what would be your response? Would it be any different if there wasn't a working group established? Because I think you refer quite a few times to some reliance on what might come out of the working group. What would be the MOD response?
Well, the working group happens to be an established forum. If it didn't exist, I think there would probably be some other sort of forum in the guise of which I do not know. If I was to give you an example, I think as Mr. Thompson pointed out in his oral evidence, we're in the middle of a climate crisis here, and MOD understands that. So there's been a lot of pan-government effort and resources over the last few years thrown into offshore, because obviously there's many offshore MOD issues as well. So we found that there was a tension between the mod position and the requirement for these offshore wind farms. So government departments have gotten together with industry to try and find solutions to this, solutions that don't exist today. So funding's been put in place, there's research projects going ahead, all under the umbrella of this forum to try and find the solution move that forward. So if the working group didn't exist, we would be left with two options. We either continue with an impasse where we've got that tension between the defence requirements to safeguard the array and the drive for renewable energy, or we look to try and corral the relevant parties to work in a collaborative way. But again, it doesn't have to be just one forum. It could be that we have approaches from whomever. We'd have to consider whatever information and data we put forward.
Just finally, I want to understand what you mean by a precautionary approach, because there could be many interpretations of that. But I want to understand, if you could unpick it for me a bit, what you mean by that term that you use, a precautionary approach in this instance.
simply to a layperson, we obviously can't risk the array compromising the detection capability of the array. That's what we're looking to avoid. So I would consider it to be a little margin of fat that's factored into the tool. Margin of fat. Yeah.
Explain that to me. What do you mean by that?
So my understanding is that it's difficult to be absolutely explicitly precise in calculating the noise. So we've got this predictive model. Sorry, let me phrase that. The model that we use is a predictive model. And it's something that, to my non-technical mind, it errs on the side of caution when it does the calculation.
So the way you're saying, the way the model has been devised, errs on the side of caution. That's where the precautionary approach comes in. Is that
yes, that's where we have our I don't know how to describe it, but that margin of fat.
So it's not, the precautionary approach is not an approach that MOD has adopted. It's embedded within the model. Is that what you're saying? It's intrinsic within the model.
Yes. Do you think there's? I'm confusing you with having a element of flexibility outside the tool.
Yeah, that's right. There's the model and then what you do with it, isn't it? The model is a tool.
Yes.
But it's then how much interpretation of that. You've explained that you can't adjust the model. You explained that to me. So you accept its findings, is what you're telling me.
Oh, yes, that is correct, Mum. Yes. So the tool will run its calculation, and it's either going to come with one of two answers: either there's budget available, or there's not. And then based on that, we'd object or not.
So just so I'm clear, so when you talk about a precautionary approach, you're talking about your use of the model that informs the precautionary approach that the MOD adopts. It's nothing over and above that. It's nothing else. No other elements come into that. No other factors come into that. It's purely based on the model.
Yes, that will give us our definitive answer.
Apologies, I'm probably being a bit pedantic, but I just want to make sure I understand what the MOD's position is on that element. Okay, no further questions for me. Thank you. Ms. Crawford.
Thank you, ma'am. Mr. Egan, just hopefully a few matters. Could I take you back to your supplementary inquiry report, please, at 4.2? We spent some time looking at this with Mr. Hardy earlier this morning. And we can see that there is a similarity of language in this paragraph, comparing and contrasting with the case. But if I could just ask you to look further into this paragraph, about 5 lines down, having set out fully defined research, etc., you then write, this encapsulates the principal difficulty that the applicant, in your view, faces. The applicant is relying on further investigation of effects, using unspecified methods, etc. What is your understanding of what the applicant is proposing to do with this condition?
Mr. Crawford, can you just clarify? Because the simple answer to that would be they would be putting something into the planning authority, something being the scheme. I'm not quite sure I understand the question.
Do you understand they're going to present to this inquiry the further investigations?
No.
Is it your understanding that whatever is produced by these further investigations is to go to a local planning authority?
Yes.
Albeit in consultation with yourself?
According to the draft condition yesterday, yes.
Have you seen investigations to date from the applicant indicating that, or, sorry, take that away. Sorry, give me one moment. Let's assume that the condition is granted. Let's assume that the applicant carries out the investigations. And let's assume that the applicant considers that it demonstrates that which it wishes to demonstrate, whatever that might be. And let's assume it consults with the MOD. Let's assume the MOD doesn't accept that which the applicant says the investigations show. In that event, I take it you would submit a response to the local planning authority.
Yes.
I'm aware you're not a lawyer or not a planner. Are you aware of being able to, of any facility which would enable you to present your technical expert to explain why it is that you, the MOD, weren't content with the investigations?
To the planning authority?
Yes.
No, I would assume that it would be a case of MOD would have to formulate its response and submit to the authority. Then we would hope that they would consider that.
But you wouldn't be able to say to the local planning authority, I wish my technical expert to explain to you, in the same manner that we often see in planning inquiries, technical experts explaining to the reporter complex matters.
No, my understanding would be, I think the analogy I used for it's like that paper balancing situation. I think the planning authority would be, and I think sorry. Sorry. I would not expect the level of scrutiny of science to occur.
You were asked many times about, in effect, the MOD wishes to have a veto. Again, let's just imagine a scenario, which I think was the scenario in June 2022, on the part of the applicant, who was offering to present its science to show that the array could be built, the false site could be built without prejudicing the array. And I don't expect you to remember the detail of the science, but you'll remember that in broad terms that was their position.
Yes, back then.
And did you at that time say, we're not going to engage, we have a veto, you're not allowed to present that evidence to the inquiry?
No, we did not.
And at that time was your expectation that the applicant would present its evidence, you would present your evidence, the reporter would test that and come to a view one way or the other?
And that is correct, that's my understanding.
And on the similar theme of veto, it was put to you, and this is undoubtedly true, that the applicant has every right to proceed with its application for planning consent or energy consent, Section 36 consent, for false site.
Yes.
You, of course, that's their right. You, of course, have your obligation to protect the array.
Yes, absolutely.
And their right to seek consent. The MOD's position is that that has to be considered in the context of your obligation to protect the array.
Yes, I'd agree with that.
Thank you very much, Mr. Eden.
Thank you for your input. Thank you. Okay, we've reached the end of the inquiry process for this week. Thank you very much for your involvement this week and for your patience at times when things didn't work quite so well right at the beginning. I think we've already discussed closing submission dates, and they are the 20th of March for the Ministry of Defence and the 27th of March for the applicant. So no change, I understand, from those dates, and I'll expect to have those in writing. So thank you very much. Thank you again, and that's finished for today.